I'd like to welcome everyone to the New York Alternative Investment Roundtable monthly call for October 2022, Avoiding Regulatory Trouble. I am Robert Akeson from the Riverside Management Group, the moderator. We are very pleased today to welcome two seasoned industry experts, Dustin Littrell, counsel in Alston and Bird's Financial Services and Products Group. Dustin's practice focuses on the structuring, formation, and ongoing operations of a variety of domestic and offshore investment vehicles, including credit funds, private equity funds, real estate funds, hedge funds, and other alternative asset and hybrid funds. He counsels his clients throughout the life cycle of their businesses as they navigate the commercial and regulatory challenges present in the investment management industry, both domestically and abroad. So we are very pleased to have Dustin join us. We'd also like to welcome our good friend, David McClean, who is the principal at the Compliance and Enterprise Risk Consultancy firm, DMA Consulting Group. David's firm provides outsourced CCO services and compliance management services for investment advisors, broker-dealers, hedge funds, mutual funds, private equity funds, CDO, CLOs, and commodity pools. He is also a senior lecturer at Rutgers University, where he teaches courses in business and professional ethics, and social philosophy. David is also the author of several books, including Wall Street, Reforming the Unreformable, and Understanding and Combating Global Corruption. And David is also a fellow of the International Compliance Association. So again, gentlemen, we are very pleased to have both of you join us here today to share your perspectives and your expertise, quite frankly, in this vitally important area. Before we dive into the topic, though, I do want to take this moment or two to thank our sponsors for their ongoing support of the roundtable and this call in particular. They include, you can see up on the screen, Alston and Bird, Baker Tilly, Deloitte, Bloomberg, New Mountain Capital, Grant Thornton, Ultimus Leverpoint, and our not-for-profit, Kaya. So just a reminder to the audience, we basically are going to have about 45 to 50 minutes of questions, at which point I will open it up to the floor for any comments or questions you might have. And I would also like to call your attention in the lower right-hand corner. You can send questions to me. You can send questions or make statements to the entire room, or you can send questions directly to the speaker. What we will try to do, however, is hold all the questions till the end. So if you send them to me, I will wait until the end of the presentation and then I'll ask them. Okay. But we're very excited to get your questions. So let's get to it, gentlemen. And let's begin with your thoughts, your comments at a high level regarding what we've seen the SEC and other regulators focus on with respect to both the investment management industry as well as the brokerage industry. Okay. And Dustin, why don't we start with you? Why don't you take us out on this question, please?
Yeah, sounds great. Thank you. And thanks all for being here. I think, from my perspective, there's certainly a lot going on. One need look no further than SEC chairman's 50 or so rulemaking items, on his near-term agenda that he published in spring. Of those many, I think we'll focus on a few. And top of mind for me right now as an advisor to registered investment advisors is the new marketing rule. I think that's a hot topic. Obviously, the deadline for compliance is November 4th. So a lot of RIAs are in the process of, updating their compliance policies, procedures to come into conformance with that. What we're seeing with the new marketing rule, it's really a modernization of the, investment advisor marketing overall. And we can go into it a little bit later, just trying to provide some high-level details here. But, at the end of 2020, you saw the SEC propose the comprehensive amendments to Rule 20641, which effectively merged the old advertising rule with the CAS solicitation rule, and then codified 60 or so years worth of no action guidance and fund industry best practices. So that's what we're seeing there. I think in addition, another proposed rule that's not going into effect, but is certainly potentially a harbinger for future rulemaking, and is certainly expected in the industry, is the new rules for private fund advisors. In February, the SEC proposed a number of sweeping new rules and amendments under the Advisors Act, focusing on private fund advisors. In broad strokes, I'd say the proposed rules are designed for additional investor protection purposes, and ultimately really break down into two separate proposals. One is the private funds proposal, which is established, to provide substantial and meaningful disclosure obligations for the protection of private fund investors, and then certain prohibitions on advisors. And then you have a cybersecurity proposal, which focuses on visibility, cybersecurity preparedness, and combating cyber attacks. Ultimately, if adopted, these new rules, would present a major sea change in the private fund industry from a regulatory and compliance perspective. And currently, there's no grandfathering language, so I think there's a lot of hesitancy and people waiting with bated breath to see what the final rulemaking looks like. Third, nothing terribly surprising here, but the SEC obviously continues to focus on environmental, social, and governance related rules and regulations in the advisor and in the broker-dealer space even. So we saw some new rules or proposed rules come out this spring along those lines. And then we also are seeing the SEC focus and continue to focus on books and records retention rules. And so, if we remember, there's quite a chilling fine that came down, really set of fines that came down from the SEC and CFTC at the end of last year on JP Morgan, where they had to pay $200 million in fines for what was called widespread and longstanding failures by the firm and its employees to maintain and preserve written communication. So we're seeing the SEC continue its vigor, pursuing actions against financial institutions and advisors for failing to comply and keep up with their record keeping and books and records obligations.
And we're going to want to come back to that in a minute. I know this is a juicy issue. I think that probably a lot of people would like to know more about. And David, let me ask you, I think Dustin really weighed in on a broad range of topics here. Would you like to add or elaborate on any of those?
Yeah, just one of them, which is actually I just did a special newsletter on ESG issues, which, among other things, the SEC is calling for naming conventions for funds, and we know that BlackRock is in the middle of a lot of this and pushing back pretty hard against certain accusations, and it's become a political football as well. So try not to get into the politics of ESG here, but the other thing that's come out of the SEC is the consideration of who is a dealer. Back in March, Gary Gensler decided with the commission that it would be a good idea to modify the definition of dealer because certain buy-side firms were providing a tremendous amount of liquidity to the market, and the thought there was that they really are operating as dealers, and the assumption there was that these firms are engaged in the business of acting as a dealer. And so the exemption from who is a dealer sort of bypassed with the proposed new definition that the SEC has come out with. And one wonders as something similar happened with the registration of hedge fund rules when the SEC staff decided what the definition of a client was through rulemaking, notwithstanding the statutory definition of client. One wonders about the statutory definition here of defining dealer through staff or commission action rather than going back to Congress to do this. So I think that's something that's going to be a real issue. I know that I've spoken to people who are very confused about who and what's a dealer. And one more point on that, there's an interesting thing that that Gary Gensler actually wrote in his press release. He says, it shouldn't be, I'm paraphrasing this, it shouldn't be presumed that that a person is not a dealer because they're not captured in the new definition. So people are just going to be wondering, am I a dealer? And of course, it's not funny at all, because if you're deemed to be a dealer under the way the registration rubric exists now with the SEC, you have to register as a broker-dealer, and that is not fun. So if you're a buy-side entity, and all of a sudden you've got to worry about licensing requirements for yourself and staff, and auditing requirements, and the whole spate of things that need to be considered here, unless the SEC decides that they're going to create a different category under the broker-dealer registration requirements, if in fact they do have the statutory authority to proceed, it's going to be a mess.
Yeah, David, can I just interject here and ask you a question on this? So
Sure.
Could you conceive of a situation where an entity is operating and is, let's say, pulled into this because of the new definition, and is in fact not currently registered as a broker-dealer? Is that are we likely to see a lot of situations like that?
That's what the proposal seems to be indicating is going to happen, right?
And so I think what you were referring to was the new membership application process, which those of us on the sell side, the broker-dealer side, who've ever been through this, know that it in effect is tantamount to death by 1,000 cuts.
Well, it's actually getting
painful.
worse. I'm going to leave aside some very painful encounters I've had with FINRA staff recently. It's getting more painful, and it's not really this. I don't want to get into the weeds on this. It's not really the staff's fault as much as it is the sort of powers that be requiring these really sort of meticulous, granular looks at the registration process. So it's very painful. And if you get, let's say you're a hedge fund, and all of a sudden you're deemed to be a dealer, and you never thought of having to register as a broker dealer. You're not none of your people.
And David, is that you would be, in other words, you would be deemed to be a broker dealer because you are selling shares in the fund or an interest in the fund? Is that why?
Well, no, you'd be deemed to be a dealer because of the frequency of your transactions in and out of a position, right? So
okay, I see.
There's no clarity on what that really looks like. How much frequency are we talking about? There's some suggestions about it, and I think it's certainly caused a lot of confusion. And I have clients that are whose counsel is telling them, and Alston and Bird may be doing this as well, to sort of private funds where the funds basically are capitalized by a small group of people with no outside investors, that they have to register because they see this as something that's inevitable. And I was going to read a list of rules and regulations that have come down over the years that have just, and it's becoming, I make a living, partly I make a bit of a living from teaching, but the rest of it comes from my consultancy. And so one would think that I would be happy about more regulation, but I have a lot of sympathy for my clients. And what did we get in the past several years? Well, Dodd-Frank, I'm sorry, we kind of asked for that, the way we behaved. But in the middle of Dodd-Frank was a lot of regulation that had to be dealt with. We had MiFID I out of Europe, MiFID II, GDPR, retention requirements for CLOs in Europe and the United States, new AML obligations, FATCA obligations, the Volcker Rule, let's not forget the Volcker Rule, new hedge fund registration and reporting obligations, going back a bit, 38A1 obligations for mutual funds that having to have their own compliance officers and report to boards, and that whole regime of new costs and regulatory obligations, which followed on the market timing scandal. Now we have rules in mutual fund land for liquidity baskets and derivatives, new derivatives rules, and regulation SAM and regulation ID, and let's see what else.
Let's not forget the Manning Order Rule, or Reg FD.
Yeah, right. FD was one of them, and now we have regulation best interest, which many people think was a waste of regulatory time, and because now we have if the marketing rules are going through, we have November 4th as a compliance date. So that's going to happen. There are disclosure obligations under the new marketing rule. Now we have to figure out how that fits in with regulation best interest and the form CRS and ADV3. Well, where do I put stuff? Where do I put the disclosures? So I'm saying all that to say to whoever's listening in regulator land, as someone who's sympathetic, who believes that civilization exists because of what you guys do in part, that it's getting kind of thick out here, and clients and firms are suffering, especially smaller firms. Most of my clients are small firms. They're suffering under all of this, and frankly, they're paralyzed because I have clients tell me all the time, I don't know what to say or do anymore. I'm afraid of my shadow because every time I turn around, I'm being told you can't say it this way, you can't do it this way.
Yeah,
it's getting thick.
And David and Dustin, it sounds to me like if you have any doubt, if you're in the audience and you have any doubt about what is going on from a regulatory standpoint, it's certainly worth the while to pick up the phone and to call folks like you. And your contact information is up on the screen, or it's. Britt, I think we can just make sure that we have the contact information up there. But it's certainly worth a call to find out what is going on. And if what I'd like to do is actually swim back to you, Dustin, and talk a little bit about or get your perspective on the new marketing rule that David said is imminent. Can you tell us a little bit more about that, Dustin, and what investment advisors need to do, what they need to do to remain in compliance?
Definitely, yeah. I know that this is sort of a hot button issue, of course. And
thank you, Britt.
Thank you. And as David mentioned, I mean, this is definitely one of those things where employees, investment advisors, in particular, who aren't necessarily in the compliance space are wondering, well, they're hearing from their compliance team, all right, well, we have this whole new set of rules. It's what can I say? What can I not say? What things should we totally stay away from? What, where are the lines that we can walk and where do we not want to cross? And so all those are things that are sort of being worked out in real time. And, the sort of drop dead compliance date is November 4th. And of course, you could have opted in at any time after the proposed rules, I believe, or well, in the last year or so, and, started, operating under the new marketing rule. But certainly for anyone who is waiting, now we're at a position where, as of November 4th, you want to make sure that you have, any communication that's going out needs to be subject to new marketing rule policies and procedures. And so, in terms of what the new marketing rule did, I mean, we could probably talk ad nauseum about it, but as an upshot, I mean, essentially it broadened the definition of advertising. So now it's going to cover a more extensive range of communications, which, a lot of it was covered by guidance and, sort of best practices, but now it explicitly includes social media and endorsements and testimonials, and, not to mention your private offering memorandums and marketing decks, et cetera. You're also bringing into scope communications on the private fund side with private fund investors directly, which aren't technically clients of an advisor, right? Because the fund is the client, and that was sort of always a question, and now it's very explicit that communications with them are subject to the new marketing rule. Then you have this set of fairly pragmatic and relatively common sense, principles that set forth, the prohibitions of what you cannot do with respect to an advertisement. And a lot of it's about, misleading and false information. And then lastly, you have your performance data prohibitions, which make clear how you treat gross versus net performance, aspirational performance, targeted performance, et cetera. So to answer your question more clearly, I think the risk alert from the SEC from September did a good job of outlining, what they're going to be looking at, which is making sure that you as a firm have policies and procedures that exist and are being followed, that you're able to comply with a substantiation requirement in the rule, which basically says that you have to have a reasonable basis for believing that you'll be able to substantiate any material statements of facts in the advertisement, which would include any of your offering documents, of course. And then they're going to be looking heavily at performance, the presentment of performance. So, for example, anything that's presented as gross performance, that has to either be accompanied by net performance data or be excluded. And so those are some of the things we're looking at right now. Okay.
And David, what are your thoughts on this? Would you like to add anything?
Yeah, I think that, anytime there's new rulemaking, there's oh my goodness, we have to get ready. Most of the stuff firms are already doing, right? So a lot of it, so you're not supposed to lie, right? And you're not supposed to have materially misleading information in your sales material. There are technical things that you need to be aware of in the new marketing rule, but for the most part, proper disclosures. If for example you're doing net, you have to include net performance. It's got to be at least as prominent as the gross, stuff like that. So I think that, I think the SEC did a good job of sort of getting rid of the no action letters, the Clover letters, and all that other stuff, making sense of how advisors should go out and market. But the rule is one thing, but it was accompanied by an adopting release that's over 400 pages long. So I spent some time last night reading through it, and it wasn't fun. But the adopting release does give you kind of the guidance. If you're confused or you're worried about something, you might find an answer by reading through the adopting release. So I would say, for the most part, while there are technical things firms should be doing, I think most firms are pretty much in line with the basic principles of the new marketing rule. The technical stuff, as Dustin said, you have to have your compliance policies in shape. And by the way, I've never seen a situation where a compliance date has come down on something as complicated as the marketing rule is, and everybody's ready. And the SEC knows they don't, in all fairness to the SEC staff, they're not out there to crack heads open. If you're trying to comply and you're trying to figure stuff out, and you leave a paper trail showing that, and you're making progress, you're probably going to be okay. So that's my 2 cents on the marketing rule. Unless Dustin disagrees.
David, thank you, and that's good to know.
I think that's right, spot on. Especially the seven overarching principles of anti-fraud, right? Those are all very common sense and what people have already been doing. I think one of the real new things, worth looking into probably is that second prong of the new definition, right? Where, the first prong is just a modernization of the existing definition. The second one is really intended to capture placement agents and third-party solicitors with respect to endorsements and testimonials. And so I think what we're seeing is, advisors are really having to go through and look at, how they've structured their solicitation agreements and things like that. So I think that's one of the new things that people are having a hard time for parsing out. But otherwise, broadly agree, it's just a good capture of what exists previously.
Good. And Dustin, just to swing back to some of the points you made in your opening comments, you talked a little bit about the record keeping rules. And I think what you were alluding to is what happened to JP Morgan back in December. Could you talk a little bit more about that, please?
Yeah, absolutely. As I mentioned, the SEC has been really focused on books and records retention. And what they've said, what the commission has said, is that from their perspective, is that when you don't keep records or do a good job of keeping records, or you're using unapproved forms of communication that go out into the interwebs and they're hard to find, they look at that as interference with the government investigation. Because if they're coming in to do an audit or investigation, they expect you to have all the records so they can review them and make determinations. So, you're affecting the enforcer's ability to do its job. And so particularly with respect to retaining information. So, for example, I think in the JP Morgan case, it took them months just to realize the fact that there were these communications that were floating out there, and because they weren't being retained or recorded in any way.
And I'm sorry, Dustin, what type of communications were being used and not retained?
Yeah, that's a good question. So, and this goes into sort of the practical advice on how to avoid all of this. So you had a group of employees, I believe a set of traders or something, that were effectively, they didn't like the internal communication tools, right? Or they weren't as effective as they could be. So they started using, I believe it was WeChat, as just a method to communicate on their phones while they're on the go, just really quick and easy. But of course, like that wasn't a firm approved, platform for communication. So it wasn't being, audited or recorded or retained or anything like that. So those were just out there.
So Dustin, just out of curiosity, and David, you might have an opinion on this too, or some insight. As I understand it, there are also mediums that don't retain records. So what's to prevent people from using them?
Well, nothing prevents anybody from doing anything. So yeah. That's the problem. So you have, okay, let's go back to where this really started. This started because we're old, Bob and I, right? So this goes back to Spitzer when he was Attorney General, and we had all the shenanigans with research reports and whatnot. And one of the ways they decided, the SEC and the Justice Department decided that they discovered that emails are a rich treasure trove of information for litigation and enforcement. And so emails became a big deal. And then text messaging and IMs became, all of these things that are used for business communications, bona fide business communications, have to be retained by the firm for the retention period. A lot of employees, consultants that are registered with firms, for example, broker-dealers, will think that, a quick text message, to, let's say Dustin, Alston and Bird is going to come. I know you're going to come next week. I want to discuss this with you. They think that's not a business communication, but it is a business communication. And if that's sent from their personal phone, that's lost to the regulators and for enforcement purposes. It's a huge problem that's probably never going to go away. What I think can be done, I have a list of things, of practical steps that I think can be implemented. One is you have to have a policy to require all electronic communications be capturable, right? So it should be approved by the firm. Where there's a slip, what I really believe in doing, and I've been saying this for 20 years now, is reminding folks. People forget, reminding folks on the calendar. Remember, put it on the calendar every 10 weeks. There's a reminder. Remember to, if you have any business communications on your personal devices, and you shouldn't, but if you do, send them to your firm email address. As long as they're captured and discoverable in the firm's records, there's no problem. It doesn't make any difference how they come in. If you've got text messages on your phone, on your personal phone that are business related, you can actually just put that on a copy machine and just copy those messages and do a PDF to your. So there are ways to address the problem. I think that just like with federal sentencing guidelines, take into consideration, proper procedures and policies, the SEC and other regulators take into consideration, serious efforts at capturing information. So for those listening, if you've done this, if you've used personal devices, if you've done stuff outside of your firm email account, just tell your compliance people or your supervisor, and then just have that stuff captured, gathered up, and then sent into the firm system, and you're fine. And just don't do that again. Don't keep doing it.
Okay, that's good input. Thank you. And so, Dustin, let me come back to you. And in the interest of time, I think we have to maybe pick the pace up a little bit, which is probably partially my fault. So, Dustin, what do fund managers need to know about the SEC's proposed rules for private fund advisors from earlier this spring? And what can we expect? What can we expect to see in the form of some actual rulemaking by the SEC in the future on this matter?
Yeah, no, that's a good question. I mean, I think in terms of, to answer your second question first, obviously these rules are merely proposed, and the SEC is currently in the process of collecting comments from the public, which are mostly negative, of course, from those who are going to be subject to additional rules and requirements. But it's a mixed bag ultimately, and I think there's clearly an intentional push for additional investor protections, particularly of private fund investors who aren't technically clients of a registered investment advisor if they're invested through a fund, right? So I think the industry is definitely bracing for Gensler's SEC to enter the rulemaking process in some form on these proposed rules in the next year or so. So that's, I think, answers the second question. I mean, in terms of what RIAs need to know, it's, as per usual, it's mostly about investor protection, right? And also a little bit of increasing visibility and establishing requirements to address practices that could lead to investor harm, and prohibiting advisor activity that's generally contrary to public interest. The SEC in their proposed rules and amended rules, excuse me, set forth a number of proposals that they thought would meet those objectives. And they have a quarterly statements rule, where you have to provide investors with quarterly statements on performance, fees, and expenses. And private fund audit rule updates on that. You have to have an annual audit for each private fund and cause the auditors to notify the SEC on certain events. An advisor-led secondaries rule, which in connection with a advisor-led transaction, you have to distribute to investors a fairness opinion and written summary of certain material business relationships between the advisor and opinion provider. And then there's a prohibited activities rule, which, as you can imagine, sets forth certain prohibited activities. Preferential treatment rule is another one where it prohibits all fund advisors from providing certain types of preferential treatment that may have a material negative effect on other investors, while also prohibiting certain types of, or really all types of preferential treatment unless disclosed to prospective investors, which implicates side letters and seed investor agreements and things that are fairly material. And then another big one is, this is the last one on my list, is just compliance rules and books and records rules amendments can require respectively all advisors to retain records related to the proposed rules, and all registered advisors to document the annual review of their compliance policies and procedures in writing. So some of those are new, some of those are going to be modified, but that's sort of the long and the short of what they're thinking.
Okay.
One of the big problems, Bob, with the proposed private funds rules, it has to do with CDOs and CLOs. They're treating CDOs and CLOs as though they're sort of, mom and pop shops with, CDOs and CLOs are structured very differently than the typical hedge fund. You've got an indenture for one, you've got trustees involved, there's usually boards involved. You have agreed upon procedures. You have auditors, usually outside accounting firms, checking the waterfall and signing off on it. So you have, it's a very different animal. And I think that the SEC is just dead wrong about auditing CLOs or CDOs. There's just been no big scandals around these. I have clients that are primarily CLO, CDO shops. It is eyeballs on everything and constant review of documentation, and to treat CLOs and CDOs like private equity funds or hedge funds, I think is a mistake from a public policy point of view, and it's going to be quite expensive to comply with the requirements.
Yes. Thank you, David. And moving on here, Dustin, how are ESG policies making their way into the scope of investment advisor compliance concerns at this point?
Yeah, quickly. I think that's been an area that we're seeing a lot of movement on lately, and certainly the proposed rules that I mentioned, those would have meant existing disclosure rules to require specific disclosures on ESG strategies. Introduce a standard table for ESG funds to disclose information in like the Form ADV that will allow investors to compare ESG funds quickly. Because I think part of the issue with ESG funds is, it's like when you buy something at the store and it says organic. It's like, well, no one really knows what that means. And there's really there's no metric for measuring it. So the SEC wants to provide an opportunity for investors to look at certain types of ESG funds and be able to compare them on a side-by-side basis. So they've developed these three categories, which is integration funds, ESG focused funds, and impact funds. So broadly, integration fund is one that's not really focused. It's not an impact fund. It's not particularly focused on ESG, but it's going to make some ESG considerations. And so you need to disclose that and disclose, for example, will pecuniary, economic gains be, subverted by ESG considerations, or is it going to be sort of vice versa? And we're making people feel good with our ESG statements. Then you have ESG focused funds, which are truly, I think, designed to be the funds that are really focused on either environmental or social or governmental issues. And those disclosure obligations are going to be even further heightened because the idea is that they're actually purporting to be an ESG focused fund. Then you have an impact fund, which is sort of like an ESG fund plus, right, where your focus is really impact versus gains, although those are not always totally divergent. But I think the disclosure obligations there are going to be heightened because you want to be able to parse through the level of ESG focus versus economic focus, and then doing so in a way that allows for comparison. And I think David had some thoughts on that as well, so I'll pause there.
What do you think, David?
Well, I mean, it's people shouldn't do greenwashing. That's the big thought, right? So don't greenwash your investment product. If you're not really concerned with ESG or impact, then don't say so. I think that's really what the commission is. It's truth in advertising. Dustin had the right idea when he talked about basically labeling. So yeah, I mean, the commission's right to go after that. Of course, the ESG issue has become a political football as well. So, if you're a libertarian, if you're lean heavily libertarian, you think this is just more, liberal nonsense. The reality is, though, the way these things happen is that whatever California thinks 25 years later, everybody thinks. So we're going to wind up with every investment product being ESG, and we won't even think of it in those terms anymore because we will simply expect managers to be doing those things anyway. So
David, on that note, let me ask you a question. Given what we've heard, what you and Dustin have described here, in terms of what the current state of regulation is today, right? What are some of the important considerations that both buy and sell side firms must consider when creating an appropriate compliance management system or a culture of compliance? What would you recommend?
Well, I don't like the language. I don't like culture of compliance talk because it's it's sort of kitschy, meaningless, but I get the point. So I have a bunch of things I could go through. I'm going to go through these really quickly. They're not the only things. Incorporate compliance topics into monthly management meetings. If you should have monthly management meetings, by the way, and leave room for a compliance topic or two to be discussed. It doesn't have to come from the compliance officer. It can come from anyone in the meeting, but have a designated bullet point on the agenda for compliance discussions. Decentralize the compliance obligation so that several managers in your shop are responsible for elements of compliance, not just the compliance officer doesn't stand there with a sausage machine and churn out something called compliance. It's really everybody's obligation in the firm.
Right.
Review your public filings, your registration documents regularly, not monthly. Who does that, right? But a few times a year, look at your ADV, look at your BD filing, look at your membership agreement with FINRA. Make sure that there's no slippage. Do you have too many branch offices, for example? Or do you have, if you're a FINRA broker dealer, make sure your registered person's U4s are up to date, that sort of thing. I like to establish regular reporting templates. I have a whole suite of these things. It's basically a lowbrow, nothing fancy. I use a vendor to make these. You could use Google Docs to make them, but everything from capturing what you found in a social media review to outside business activity, all sorts of things. I have designated forms for that I ask my clients to use because it takes the guesswork out of how to report internally, what you're finding. I even have one for the annual review obligation. Is it the final thing? No, but it gets you started on. So, regular reporting templates are a good idea. Simplify your compliance policies and procedures. And when I started, in 1989, when they first came out with, this is long before the Investment Advisors Act required them, when the NASD came out with the requirement for supervisory procedures, I remember I was at Van Eck Global at the time. We had a wafer-thin document that was adequate. Now they're 500 pages long. It's really dangerous to have a 500-page compliance manual because a lot of stuff in there you're not doing. And you're setting yourself up for a real problem. And if the SEC, SEC knows this and FINRA knows it, and they'll tell you take that out, or they'll give you a chance. But if they come back and it's still in there and you're still not doing it, then you're going to get, you're going to face some serious issues. I believe in constant internal communications. I tell my clients, sort of half jokingly, I send you a lot of stuff during the year. It's boring, but I have to do it, right? So,
Sure.
So constant communications, short and sweet. Like, for example, Dustin can send a communication today. Hey, remember November 4th is coming, and I'm going to spoon feed you pieces of the new marketing rule over the next 10 days. So you can have all of that in your email.
Yes.
Right. That's stuff like that.
Okay.
And prepare for SEC and FINRA exams. Don't wait for the knock on the door. Start thinking about the next exam now. And, keep an eye on your CRS, your ADV Part 3. Make sure that you don't make it and just let them sit there on the website. They should be refreshed from time to time, if necessary, but you should at least look at them. There's a few other things, but
that's good. I think you've really cut into it very nicely.
I think Dustin, communication is key here. With
yes, I think you've made that very clear. Yes. Yeah. Dustin, what about you? Any thoughts on this topic?
Yeah, I think what David said, I would, I could echo each one of those. I think that's all right. The one thing in addition that I would say is I think a lot of these clients that I see, they look at, facing down a large or, any law firm's bill, right, to review their compliance manuals or help them come into compliance. And I usually don't negotiate against myself, but rather than try and do it yourself or go in-house, find a service provider that is going to work for you, right? Compliance consultants are extremely knowledgeable and efficient, and I think I run into a lot of clients who are like, well, we don't want to pay your rate. It's like, well, then don't. Go find a compliance consultant who can do a really great job for you, and so don't wait and don't try and do it internally unless you have, the appropriate apparatus set up. Reach out to your attorney, reach out to your compliance consultant to make sure that you're doing things right.
Yeah.
Okay. Very good. Sound advice.
Just one quickly on that point. I tell my clients when we're rewriting compliance manuals, this is going to take about 1.5 years. So don't, because you don't want to chop out stuff that you really should have in there. You really have to think things through section by section. Otherwise, you can wind up in trouble. But it's, it should be done. It should be simplified.
So David, on that point, okay, and you also made the allusion to the fact that you've been around a long time. Okay. So my question to you is, what changes in approach and attitude are you seeing from regulators, let's say in recent times? That would be one question. And then I think another question would be, what are some of the problems that you're beginning to see in firms, and how can they be avoided? And I think you've sort of touched on this in some of your other comments, but let's begin with the regulators. What have you seen? What change of approach, attitude, ethos, whatever, have they changed?
I don't really think they've changed. I think that there's pressure coming from above on them, on the staff at FINRA and the NASD and the NFA. And I think there's pressure from above, and the pressure, let's be honest about some of this. Some of this we brought on ourselves in the industry. Through bad acting, you have headlines, the headlines lead politicians and legislators to act, and then they act, right? And usually when they act, they come out with some kind of spate of rules that, keep Dustin and our bank accounts in the black, but they're painful. So in terms of some processes, there's a lot of pedantic, minutia that has to be dealt with. I'm not going to get into the specifics on that because I got to deal with these people as Dustin does. But it would be nice if what we need, I think now, those of us that are running honest shops or trying to be honest anyway, we could use a phone call instead of a nasty letter. I got a letter, I will say this, I got a letter from someone at FINRA from Rockville. I was trying to get a waiver for someone so they didn't have to take the series exams again. And they denied the waiver, which kind of expected. And they said, okay, well, you need to U5 this person, or deregister this person from your firm, or face enforcement. I'm like, what? The chilling effects of lines like that,
Yes.
They're not helpful.
It comes across as being a bit harsh. Yes.
Yeah, it's way too harsh, and it makes me basically get combative. And I'm not afraid of regulators. I don't want to pick fights, but why would you say that over something as minor as this? So is that kind of thing. We need a better approach to sort of engagement with the people that are being regulated who are honest.
Sure.
Not everybody's
understood.
Yeah.
Dustin, any further thoughts on this before we move on?
Lawyers can always talk, but I think we've covered it pretty well.
Okay, so let's move on then. I think this is very important. It's certainly for the people in the audience. So, distilling what I've heard both you gentlemen say, there's protecting the firm, there's protecting the clients, and then there's protecting managers and staff at these firms. What let's say 2 or 3 suggestions do you have concerning how to protect each one of these stakeholder groups? The firm, clients, and the staff.
I'll take a shot at the staff just because that's kind of an interesting one that applies, I think, particularly in the records keeping and rules and enforcements we've seen. And part of it is protecting them from themselves, right? And
sure.
The other half is enabling them to protect the firm while protecting themselves. And so, having good policy procedures in place is going to protect the firm and protect the employees, because, as David mentioned, having something digestible and simple is going to be the best way to actually abide by relevant rules and regs that apply to you. But you also need to be thinking about, I think, your employees in a way that's meaningful to them. Like, so for example, on the communications issue that brought up the fines to JP Morgan,
yes,
if you're working with teams and you're using antiquated, communications methods, be open to changing, take the hit on adopting something that's maybe a little more expensive. Or, I don't know how much these things cost, but that's got a mobile application for people to use while they're on the go, so they're not as tempted to send a text message. They know they can open up their application and communicate in a meaningful, immediate, and effective way.
Okay.
That's one thing that I would say.
Fair enough. And gentlemen, in the closing minutes that we have here, closing time, given your respective backgrounds and professions, in fact, what are some of the new rules or regulatory changes that you see on the horizon? Okay. And what do they mean for those people listening in the audience, the investment advisors, the sell side folks, hedge fund managers, private equity, et cetera, et cetera? David, why don't we start with you?
I think we pretty much covered those. Right? The things that are on the horizon are the proposed rules that we went over, the private fund rules, the marketing rule, the ESG rules. So yeah, I think we did cover those. Okay. I don't think, of course.
Justin, anything you'd like to add there?
FINRA always has new proposed rules coming all the time, and but that's another show, I guess. We have to talk about that somewhere else.
Absolutely, we'll have you back.
I agree with that completely, and I'd say if anyone's interested in looking at what's coming down from the SEC, I mean, you can look at those 50 items that the SEC proposed as their near-term agenda for this year, and quite comprehensive.
Okay. So gentlemen, in the remaining moments that we have a couple of questions here from the audience. One is retained business communications. Okay. They include all communications among employees that are business related, or does it just mean, or does it just involve client facing and or related communications?
Everything.
Yeah, everything. And not to be conflated with the advertising rule, which right does relate only to sort of client or prospective client communications for the most part. So yeah, but in terms of the record keeping rules, that's everything.
So gentlemen, if a client reaches out to a registered person via text and says, I'll see you there at 1 p.m. for lunch, is that a communication that needs to be supervised by the firm?
It needs to be retained by the firm.
Needs to be retained. That communication needs to be retained.
Let me tell you why. Suppose there is litigation or there's an enforcement action, and that particular text message was the linchpin in whether or not someone was engaged in bad acting or not, right? In discovery, right? So yes, that's why what's perceived by a regular person, right, as an innocent, I'm going to meet you for lunch at noon. Well, as it turns out, I was going to meet you at lunch for lunch at noon because I had inside information, right? And so that's why all of it's the only thing. What I tell my clients is the only thing that's not business communication is, you're texting your wife or your spouse about the dry cleaning or your grocery list. That's clearly not business communications. You probably shouldn't be doing that through the firm anyway. But basically everything else is, unfortunately.
Okay. And to add to that, I'll say, if it ever comes down to a situation like David's describing, and someone, the regulator asks, is there any other, communication? You say, well, I guess we did text. Well, now you've got the DOJ opening up all your text messages and reading the whole thing.
Yep.
That's really good to know. I think people in the audience will appreciate that. Again, in the remaining time that we have a few other questions from the audience, and I'll summarize them the following way. What they're asking for are any tips that you gentlemen might have with respect to registered investment advisors, broker-dealers. So why don't we begin with those? What tips do you folks have that you haven't already covered for investment advisors and broker-dealers?
They should hire us.
That's right.
That was a given, David. That was a given. That was a given.
You have anything to add, Dustin, to that?
It's so eloquently said. Find a way to stay abreast of these issues, whether that's through talks like this or automatic email mailers, from David, or I know David's website has a lot of information on it, or you can get access to it. And, your law firm's probably providing, updates, compliance updates, and things like that. So just stay abreast and don't hesitate to reach out. and
I've got a
engage with us.
suggestion. I've got a suggestion for CEOs in firms.
Yes.
Once a year, as Fink does at Blackstone, at BlackRock with his annual letter. I think it's a good idea for CEOs to send to use your language before, a culture of compliance type communication throughout the firm, right? As CEO of the firm, this is what I expect. We're in this business. We're fiduciaries. We have these obligations. Don't send the same one out every year, but send out a thoughtful letter to your entire team. And in terms of the layering of protecting management, the firm, obviously you want to protect the investor and the customers, but there are layers here. And I think that the C-suite folks would do themselves some justice if they took proactive efforts to communicate their expectations. And again, just like with the federal sentencing guidelines, a letter like that covers a lot of sins, right? Even if it's purely cynical, which I don't know anybody that's that cynical, but even if there's a cynical element in it, it's still true. You really ought to be doing the things that they're saying in the letter. So I actually drafted letters back in the mid-aughts for CEOs to send out, and a few of them did firm-wide. And it's good to have in the file.
Yes.
Yeah.
And gentlemen, one last question. This won't go away. Texting. This is from the audience. Should you then have a cell phone that is exclusive for business only, so that all texts and emails, et cetera, are captured on that device?
Ideally, yes. Yeah. What do you think, Dustin?
I think, pragmatically, maybe, that's super annoying to do.
It is.
But yeah, ideally, I think, you just limit your communication to a really usable application that's backed up on a server that you own or have access to. Your email, for example, that exists already. If you use Slack or what have you, those things are all going to check that box.
Yeah.
Just don't send text messages. Even, I would say, even if you did have I know they're hard to get back, right? You have to go to the phone company and get a printout or however that works. So just text message, I think, in general, is just not great.
Yeah.
No, understood. So, gentlemen, I would say that our time is about up, and I'm going to ask each of you to make whatever closing statements, commentary you'd like to make, if any at all. We've obviously, you've done a fabulous job covering a wide range of very important topics. And I would also, here we go, thank you. Both Dustin and David's contact information are up here on the board. So take a look at that. You can see that they were both very generous with their time and their insights. So by all means, please feel free to contact these folks. And we certainly look forward to having you back in the future. But again, on that note, David, Dustin, would you like to make closing comments in about a minute's time? Each have 30 seconds.
Good.
Yeah, I'll just say thanks for having us, and thank you to NY Alt Roundtable for hosting this call, and everyone for joining. And don't hesitate to reach out, and we can chat about whatever you need.
Thank you, Dustin.
I'll make a pitch for the roundtable. So you should all become members if you're not. The pricing is pretty good, excellent actually. So think about becoming a member of the roundtable. Other than that, remember that you're facing the government when you're dealing with regulation. Not a joke. You're facing an 800-pound gorilla, and you don't want to be on the wrong end of that if you can avoid it. And avoiding it is pretty easy, actually, if you're just consistent.
Terrific. So, Dustin Littrell and David McClean, I want to thank you on behalf of the roundtable for your very timely, interesting and thought-provoking perspectives on how to avoid regulatory trouble.